Does a company owe you money? Are you a director of a company that owes somebody else money? There is a simple and inexpensive way to recover debts owed by companies. We call that simple and inexpensive way a creditor's statutory demand. Okay, well, when should we use a creditor's statutory demand? Well, the Corporation Act says that we can issue a creditor's statutory demand to a company that owes us more than $2,000. To issue the demand, we need to make sure it's in the appropriate form and accompanied by the relevant affidavit or affidavits. When the company we are chasing up for money receives a statutory demand, what can it do? Well, a company that is on the receiving end of a statutory demand can do one of two things. It can pay the amount demanded, and end of story. Or it can bring an application in the Supreme Court to have the statutory demand set aside. The company must do either of those two things within 21 days of being served with a statutory demand. And I'll stress, the 21-day period needs to be strictly complied with and can't be extended, not even by a court. Now, what happens if the company does not comply with the statutory demand? Well, the company will be deemed to be insolvent under the Corporations Act. This means that the company is at a real risk of a court later ordering a liquidator to be appointed to wind up the company. There may also be some other nasty consequences for the company. For example, if the company is subject to any financial arrangements, it is not uncommon for the loan agreements to contain provisions defining an act of default to include situations where the company is served with a statutory demand or is subject to a winding up application. So, not only is the company at risk of a liquidator being appointed, it may be that the financiers will independently call up any outstanding loans and or appoint their own external receivers and managers. Okay, well, how can a company set aside a statutory demand? Well, the company would need to bring an application in the Supreme Court and ask for the statutory demand to be set aside on any of these grounds. The first ground, the company may claim that there is a defect in the statutory demand it received, which causes substantial injustice to the company. Some examples of such defects include that the demand was served at an incorrect address, or that the accompanying affidavit contained errors. So that is one ground that the company can use to contest the statutory demand. Number two, the company may claim that it has an offsetting claim against the creditor. So that ground is pretty self-explanatory. Finally, number three, the company may claim that it has a genuine dispute about the existence or amount of a debt to which the demand relates. Okay, what does it mean to have a genuine dispute about the debt? Well, to show that there is a genuine dispute, all the company has to do is to point to the facts and circumstances in an affidavit which, if proven at a trial, might give rise to a defence, even a weak defence. The point is, the threshold for demonstrating whether a genuine dispute exists is set very, very low. A company that can put the whiff of even a potential weak defence before a court might successfully have the creditor's statutory demand set aside. If the company succeeds, the creditor, that is the person who issued the statutory demand in the first place, will be faced with the likelihood of being ordered to pay the company's legal costs of the court proceedings.